before we begin, in our enthusiasm to get through this morning's submissions, I forgot to have a break for the transcriber. So we need to have an appropriate break this afternoon. And that might mean that the person speaking second, I'd ask to organise their submissions so that they allow for a break with the transcriber. All right?
Could I, in fact, ask for a break before my submissions?
All right.
Would that be possible? Because
Yeah.
I need to take more instructions.
All right, fine. Well, that may solve the problem.
Thank you, sir.
Sir, I've told the transcriber I speak quite slowly, so hopefully that will help. So I make these submissions today on behalf of the core participants who Mr. Steen, KC and I represent. We're instructed by Howe & Co, who act for 156 core participants, including 60 applicants under the GLO scheme, 10 applicants in the HSS, and 5 applicants under the overturned convictions scheme. And some of our clients, we're very happy to say, have attended today. So you have our written submissions dated the 13th of April, tab A2. Before I start, I would like to say, in fact I'm instructed to say, that our clients firmly believe that any progress that has been achieved in relation to compensation is very largely due to the fact that the inquiry has taken an active approach on this point. And our clients have asked us to urge that the inquiry continues to hold these hearings and publish progress updates to ensure that DBT and POL meet their commitments to the victims of this scandal. We understand that Mr. Henry, on behalf of Hodge, Jones and Allen today, will be proposing that the GLO scheme is restarted from scratch. We've thought about that suggestion, and although we completely understand why the suggestion is being made, we're unable to support this proposal because our clients instruct that they need compensation now and can't afford to wait any longer. So my submissions are based on how we work with the scheme as we have it now. And so there are 3 headline issues that I would like to draw your attention to. Firstly, and it might come as no surprise after this morning's hearing, that the deadline of the 7th of August 2024 for all processes and payments under the GLO scheme is simply unworkable. The second point is that the delays by the government are negatively affecting and in some cases re-traumatising our clients. And the third point, sir, is that this scheme must, we suggest, include consideration of facts that are being established now within this inquiry. Fair compensation must include fair consideration of all the facts. So on the first issue, the 7th of August 2024 deadline, we know that the scheme sets out at 4.4.2 that it is to enable payments to be made no later than the 7th of August 2024. And in your January 2023 statement on compensation issues, you said at paragraph 39 that the effect of this deadline was that approximately 550 claims would have to be considered in the course of the next 20 months. And so you said today, which I adopt, that it's 414 months now. So it's not getting any easier or better. Freeths have sent a letter into the inquiry dated the 20th of April 2023, and they've expressed serious concerns over the August 2024 deadline for the scheme. Part of the problem, they say, is that the scheme can't move at a reasonable pace because of the process of disclosure of documents by Post Office Limited. That's been exceptionally slow and been made unnecessarily complex by Post Office resourcing problems being cited by them as the major issue. And Mr. Chapman confirmed this morning that there's no issue about meeting costs on disclosure, but it is a resource problem. And Freeths are extremely concerned, they say, that there will be insufficient time for DBT to conduct a full and fair evaluation, and that there's an obvious risk that compensation offers will be made by DBT without there having been time for consideration of expert accounting and medical evidence. Our position hasn't changed for quite a while. We raised this issue, sir, with you in Howe & Co.'s letter of the 9th of January 2023, which is in the bundle at tab B7B. We repeat these concerns, and we agree with Freeths that the August 2024 deadline does represent a serious project risk. And it appears to our clients that the scheme will barely have got off the ground before the clock runs down, before the claims are timed out. This would, we say, represent yet another scandal for our clients. As Freeds have commented, there's a real problem with the Post Office giving disclosure in respect of compensation, and this perhaps may not come as much of a surprise because we know that disclosure is a recurring theme problem with the Post Office in this inquiry. We've referred at paragraph 30 of our written submissions to DBT having informed Howe & Co by email on the 4th of April this year that POL explained the constraints that mean the full set of disclosures will take 32 weeks, and Mr. Chapman dealt with the 32 weeks point in submissions today and said that this estimate is being revised. But the problem that we see, sir, is that the matter is still in flux. We have nothing specific. We have no date or time to give to our very anxious clients. And this is part of the problem. We're constantly being told, or our clients are constantly being told that something will be done, but they don't know when it is going to be done by. So those who instruct me are very interested in putting forward solutions that are pragmatic and might assist the inquiry. And we propose two solutions to perhaps overcome this, what might be an existential problem for the GLO scheme. The first solution that we propose is that you, sir, impose a timetable for the GLO scheme to deal with disclosure, offers and reviews in a meaningful way so as to avert the disastrous consequences that would follow from any further delays by DBT and POL in relation to the GLO scheme. The imposition of a timetable by you, sir, would require Post Office to really get on top of disclosure and perhaps almost like an unless order, there could be a provision within the timetable that if disclosure isn't forthcoming by a certain date, then presumptions will operate in favour of the applicant. It would also enable DBT or require DBT to remove what we say is unnecessary bureaucracy in the scheme. We don't understand why there has to be a role of a facilitator, and we don't understand why so much time is being taken to approve requests for expert evidence. A timetable would concentrate minds in this regard. By way of a suggestion, we think that perhaps the progress from start to finish ought to take no more than 8 months within this timetable, and that would give us a sufficient buffer for the August 2024 deadline. We know from what Mr. Chapman told the inquiry this morning and from what is written at paragraph 41 of DBT's written submissions that the department is working with Denton's, independent claims facilitators, and Adelshaw Goddard, DBT's legal advisors, to agree a detailed timetable for the scheme against which the scheme will be monitored, delivered and publicly reported. The submissions go on to say somewhat ominously that the timetable will be reported to the inquiry when it has been agreed. So the difficulty with DBT's position is that there is no timetable for a timetable. And we're only 14 to 15 months away from the time when the department's legal powers will expire. And our clients cannot be expected to put their lives on hold waiting for DBT to agree a timetable with a variety of other parties. They've waited long enough, sir. So the second solution that we propose is the appointment of an overseer, perhaps or ideally a retired senior judge, with power to resolve disputes in the GLO scheme and to ensure that the scheme is delivered effectively and in a time-efficient manner. This has been done before and to good effect. So you will recall that Sir Anthony Hooper was able to manage the mediation scheme in a robust and efficient manner. And we say that a similar appointment is necessary to allay our clients' very real concerns over the deadline and to wrest control of the scheme away to the government and place it in the hands of an independent figure. If this problem is left unchecked, there will be a very real possibility that a current application in a complex case that proceeds to review stage would most likely use up all of the time that is available. Now, I've spoken to one of the claims lawyers at Howe & Co, who has given me an indicative timescale of how long it would take to process a claim that was complex and proceeds to the review stage. And she says that May 2023 would involve perusal of post office documents if they'd already been received, if they'd already been disclosed. June 2023, perusal of hospital records. July 2023, draft first witness statement. August 2023 is when it would, and it's anticipated that authority would be received for medical or accounting reports. September 2023, that's when those who instruct me would expect to receive expert reports, and that's somewhat optimistic because there are only a limited amount of experts, and I expect they're all going to be very busy in this area. October 2023 would be preparation of witness statements and a schedule of losses, and the preparation of a bundle to lodge with Dentons. November, December 2023 would be a first meeting following an offer from Addleshaw Goddard. And then, of course, we have Christmas and New Year intervening. So a mediation would take place in January 2024, a first panel meeting, non-binding, March 2024, a final panel meeting, which is binding, May 2024. A review would take place in July 2024, and final offer and completion of the matter in August 2024. So when looked at and when analysed from the point of view of a compensation lawyer, if a case is complex, it's going to be very, very difficult to resolve it in the very limited time frame. And this is, in my submission, the stuff of sleepless nights for compensation lawyers. And so you've already indicated this morning that is a matter that you've viewed with anxiety. There might even be less time, and one shouldn't speculate, but that if there's an autumn 2024 general election, DBT will be required to enter into a period of purdah which will effectively halt matters for, I believe, 3 months. There are other reasons why an independent overseer would be useful, and we say that the appointment of an overseer would protect the victims of this scandal from some of the more objectionable views or actions of the scheme's administrators that we've recently witnessed. And for example, on the 25th of April, only 2 days ago, DBT wrote to a number of representatives of GLO scheme applicants and stated, and Mr. Chapman covered this morning in his submissions, but I'll read out what was said. We want to maximise the proportion of our spending which goes to postmasters rather than to pay for the compensation process. To ensure a proportionate approach and that we're only using expert evidence as far as reasonably necessary to assist claimants with their claims, we're asking Addleshaw Goddard to develop some standardised approaches to common situations, working with those claimant legal advisors and their experts who have significant numbers of clients in the scheme. This work should help us process claims more quickly with less to and fro between the parties. Once developed, these standardised approaches will be shared with representatives of all claimants. They will not be rigid, and each case must, of course, be considered on its merits, but we hope you will find them helpful. What we say is this is another layer of decision-making, another administrative layer of delay. And our position is that this approach represents a serious misstep. It is not for the DBT, it's not for DBT to determine whether expert evidence is needed in any particular case. That must be the decision of each applicant's legal representatives, lawyers and officers of the court. They are in the best position to know what evidence they need for their clients, acting in their clients' best interests, to advance their claims. And if that's expert evidence, it's a decision for them, not for the DBT. And this is an example of further unfairness in the operation of the scheme, which will only lead to more delay. And it's a good example of the sort of issue which an independent overseer could grapple with and resolve very quickly. So the solutions that we propose, the imposed timetable and the appointment of an independent overseer, we say are reasonable and pragmatic, and we hope that the inquiry will adopt these suggestions. we've proceeded, of course, on the basis that the August 2024 date is set in stone, because that's what the DBT has told the inquiry. It appears that there was an Appropriation Act which fixes funding to that date. We don't, however, know the exact legislative basis for the deadline, and we would like to know from DBT the particular legislation involved, so we can look at it and we can advise our clients accordingly so they can understand. We would also be very interested to know whether there are any contingency plans in place for when and if the clock runs down on GLO scheme applications. It's been said this morning by Mr. Chapman, it's not within the department's gift to extend the deadline. We would like to know whether there can be, or whether they should be, or whether there are any contingency arrangements, so that we can explain that to our clients and advise them accordingly. So the second issue is the consequences of ongoing delays. And we want to say that the government has unacceptably delayed in publishing the GLO scheme. Howe & Co called for the establishment of the GLO scheme in correspondence with BEIS, as the department then was, as long ago as October 2021. That's over a year and a half ago, sir. The scheme was published only onto the 23rd of March 2023. And yesterday, perhaps in keeping with a tradition for there to be a ministerial statement the day before an inquiry hearing, there was a ministerial statement which said that the department will publish a revised version of the guidance in due course. Now, in fairness to the department, the statement has taken on board a number of issues which have been raised by core participants in this inquiry. But it is unhelpful, sir, that the department continues to make announcements on the very eve of every compensation hearing, it seems. And this wasn't foreshadowed in DBT's written submissions. If there is going to be a ministerial statement in the future, we'd like to have some advance warning of it. We say that the decision to amend the guidance is in response, I think it's quite clear, it's in response to the views of the Horizon Compensation Advisory Board. But this further delay would not have been necessary had Howe & Co, who represent approximately 130 GLO litigants, been meaningfully consulted on the scheme prior to its publication last month. Now, I hear what Mr. Chapman has said, of course, about consultation, and my instructions are that there have been discussions, but every decision is presented as a fait accompli. And perhaps an example of the approach that has been taken is that yesterday there was an announcement by the Minister that there would be changes to the scheme. Howe & Co knew nothing about that, and I assume no other representative of core participants or applicants under the schemes, potential applicants under the schemes, would have known. The real issue, sir, is that these delays are affecting our clients, and we suggest that there should be a second stage of interim payments that could be based on the first offers that the scheme produces. There is no rationale for holding any money back until the final resolution of an application. So it's often the case that the best proposals for action to be taken come from our clients, from those who are directly affected. And I would like to read out a letter that we received, I think, yesterday from Chris Dawson, one of our GLO clients. And he said, "I write to ask that Howe & Co ask the Chair to recommend a second round of interim compensation payments to be made by the Department of Business. I'm sure I'm not alone in being grateful for the interim payment, albeit I wish it had been made many years ago. However, that interim payment was made some months ago, and I am also sure I am not alone in respect to having to use a considerable amount of the interim compensation to pay off debts accrued in the years since being made bankrupt. With the current cost of living crisis, fuel prices, food price increases, electricity and gas prices, I am finding myself living hand to mouth. Again, I am sure I'm not alone in this. It has taken years for Post Office and Department of Business to agree to pay any compensation at all. Last June, they made big announcements about a compensation scheme for postmasters who were part of the group action. However, it is not far off a year since that announcement, and the compensation scheme appears to be moving at a snail's pace. It is not fair to ask postmasters like myself to wait for POL and the DBT to get their act together and move things forward so that postmasters can receive final compensation. If they cannot do this efficiently, then at least they should help me and others out by making a further interim payment. Although I'm asking you to raise this with the Chair, I'm embarrassed to do so, as it makes me feel like I'm going cap in hand to those who wrecked my life. And this is very much of the psychology of how a victim feels in these processes. They feel that they have to ask someone to compensate them when it should be the authority that is making those approaches. Francis May, another of our clients whose interim payment was taken in part by a bankruptcy trustee, has told us that he's learned to live with the mindset that there could be a disaster at any time. He said last week, I've got used to things hanging over my head. It's embedded in my head that the rope can be pulled from under me again. It's always there. It will never go away. The husband of Isabel Paul, who died very sadly before she was finally compensated, Peter, he says, Isabella was found not to have committed any crime, but deemed unfit to run the post office and required to pay back thousands of pounds because Horizon had recorded large shortfalls in the accounts. Isabella was suspended indefinitely. We continued to fight the cause, but eventually were forced into bankruptcy and an IVA. We lost the post office and store, 2 flats above, all our savings, investments, and health and retirement. I am working. I still owe thousands of pounds. Suzanne Palmer is unable to move from a tiny flat in an area where she feels unsafe because of the ongoing consequences of her bankruptcy and the scandal. I have received, and Mr. Enright and Mr. Steen have also received many other messages from other court participants. Time does not permit me to read them out. But the important point is that all of these clients are still suffering. Aside from the seemingly never-ending financial difficulties that they continue to face, our clients who were made bankrupt as a consequence of this scandal also live with the stigma of having been made bankrupt. Miss Palmer told me that she remembers bailiffs putting her furniture out on the street in the view of all her neighbours. We say that everything possible must be done to alleviate the ongoing suffering of our clients. An obvious solution, sir, would be a second interim payment. And as I've already said, by way of an example, if an initial offer under the GLO scheme is rejected as being too low, there would be no reason for DBT not to pay that sum pending resolution of the final compensation award. So the third point is about assessing compensation on the basis of the full facts. In the course of this inquiry, sir, we learn in every new tranche of disclosure and at every hearing more of what happened. The deliberate stigmatisation of postmasters as criminals, notwithstanding no proof of offending, the deliberate turning of the screw against postmasters within the impact programme, the desire to win cases against postmasters whatever the cost, and the deliberate suppression of the truth. And we can all see that the judgments of Mr. Justice Fraser in the High Court were hugely incriminating against the Post Office. But these findings were incomplete because the trial process didn't conclude and do not portray the very worst of it. And we will see that, and we will continue to see that as the inquiry progresses into its next phases. But despite the worsening picture for POL and DBT, the scheme guidance says that the scheme will be divided by considerations of fairness, in addition to applying established legal principles and the findings from the Common Issues Judgment and Horizon Issues Judgment. We say it shouldn't stop there. Instead, the scheme must, we suggest, include consideration of the facts that are being established now within this inquiry. Fair compensation must include fair consideration of all the facts. There is, of course, a tension because no one wants the payments for the GLO litigants to be delayed for even a day more than necessary. But in my submission, sir, we have to be realistic. The facts under examination in this inquiry will, and not may, be relevant to consideration of the extent of harm and pain and suffering within traditional models of compensation assessment. The GLO litigants module comes close to the end of this inquiry. I think it's phase 5. And there will be facts that will affect compensation payable that will emerge within that module. When the inquiry investigates the conduct of the litigation in phase 5, no doubt our clients will be forced to relive much of what happened to them and will have access to more detail of just how appallingly the Post Office acted towards them. And this is a factor, sir, that we say needs to be incorporated into all of the schemes. Sir, I'm conscious of the time. I will briefly address you on other matters,
Yes.
and I'll do it so as quickly as I can. As far as the historic shortfall scheme is concerned, How & Co Act for 10 claimants who are making applications. There are problems with delays, and I appreciate Ms Gallifant having apologised in relation to one of our clients, I believe Ms Elliott, who's been affected by the delays, and it may now have to face entering an IVA. One of the problems, it's important though that Post Office recognise that the delays are inflicting harm on our clients and contributing to their suffering. A particular concern that How & Co have had is that it's difficult to go into a good faith meeting fully armed without an expert report to establish what it is the claim is about, and those are taking time. How & Co Act for 5 clients in the overturned conviction scheme, and we've said in our written submissions that a dispute has arisen in relation to whether payments received under the 2019 settlement agreement should be deducted from the final payment made to applicants in the overturned conviction scheme, but who are also in the group litigation. How & Co's position is that payments to the GLO in the settlement agreement expressly excluded malicious prosecution. This is a matter which we would like to perhaps lay down a marker for the inquiry to consider when dealing with the settlement agreement in phase 5. There is a related point to the August 2024 deadline in respect of clients who were made bankrupt and have entered into IVAs being in a more precarious position in relation to the GLO scheme. And this is because bankrupt and IVA affected sub-postmasters are required to discharge a more onerous evidential burden than applicants who are not burdened with trustees or office holders. And the GLO scheme requires that applicants who've been subject to bankruptcy must provide details and documentation to support their claims, and they're additionally required to demonstrate that the bankruptcy insolvency was due to the Horizon shortfall.
Mr Jacobs, can I just ask you, because I obviously haven't got them at the tip of my fingers, are you saying that the evidential burden for GLO claimants who were made bankrupt is a different or higher burden than is applied in HSS for bankrupt people?
Sir, probably not, because they still have to produce all their accounts, produce all the details of their bankruptcy.
Because as you'll appreciate, what I'm concerned about is overall fairness and consistency. And I would obviously be worried if schemes were applying different criteria.
Of course.
But I take it from what you've said that what GLO effectively does is reproduce what is in HSS about proof in bankruptcy cases.
Absolutely, sir. I think the point that I was trying to make was that the more onerous evidential burden means that it's going to be more difficult for them to hit the August 2024 deadline.
Well, I think there's, as I said this morning, there's it's like that piece of rock with something running through it, and August 1924 is certainly a strand that's bound up with all these things.
Absolutely, sir. I can also say that there's likely to be an issue in relation to aggravated damages. We say that it cannot be only the case that aggravated damages will follow when the Post Office was the petitioning creditor. Francis May, for example, told us that the Post Office told him that they'd blocked the sale of his lease unless Horizon debts, which had led to the sale in the first place, were paid from the proceeds of sale. And he instructs that had he been given reasonable time to pay the Post Office, it's likely he would have been able to avoid bankruptcy. There is a but-for presumption that we submit ought to be necessary. We ask that that aggravated damages are paid where it can be established that but for the Horizon shortfalls, the sub-postmaster would not have been made bankrupt. There doesn't have to be a nexus between the Post Office being the petitioning creditor and the award of aggregate.
I don't wish to sound unhelpful, but you are trying to ease me into the position
Yes.
where I cannot be with these submissions, Mr. Jacobs, since the statute specifically prohibits me from determining civil liability.
Absolutely.
But I understand that you use me as a forum for some of your submissions.
I shall avoid doing that and move on. There are outstanding issues with insolvency practitioners, we've heard from Mr. Chapman, and it's more. We say that it would be entirely proportionate and appropriate for DBT to commence proceedings almost immediately if Moore doesn't respond positively to the opinion of Ms. Addy KC. And we echo your comment that you made this morning, sir, that a swift resolution is needed. It's also important that applications for annulment and rescission proceed as quickly as possible, because those are the very devices that can have the best means, certainly in relation to stigma, of restoring people to the position they would have been but for the scandal. If there's a public acknowledgement that they should never have been bankrupt in the first place, that would mean a great deal to very many clients. Some of them will say, well, it's too late now, but others may very, very much want that relief. We say that the Post Office should do everything they can to support those applications, and we've asked for witness statements for use in annulment applications where the Post Office agrees with the test and agrees that the order for bankruptcy should never have been made. That will certainly make the passage of these claims go much quicker through the courts. So we don't agree that this is something that's not necessary, because Post Office are already communicating with sub-postmasters. We don't think necessarily that there are data protection issues. We would only ask for information in respect of our own clients. But this is something that is proactive, that the Post Office can do to ensure that these claims are dealt with in very short time periods. We all know how long the court process can take. In relation to payment for an annulment and rescission where the Post Office was not the petitioning creditor, again, we ask for a but-for presumption that Post Office should pay for the rescission and annulment applications where the Post Office wasn't the petitioning creditor, where the horizon shortfall or actions of the Post Office materially contributed to the sub-postmaster or another party making an application for bankruptcy. We've also asked that GLO modifies, that DBT modifies the scheme, the GLO scheme, to expressly provide for funds for SPMs to receive legal advice on matters in relation to annulment of bankruptcies and rescission, and that they help facilitate the making of such applications where appropriate. So moving on to IVAs, Ms. Addy Casey's view is that as IVAs operate on their individual terms, it's not possible to generalise in relation to what the assets will or will not be caught by them. We ask that there is a reflection in the scheme that there is an appropriate degree of flexibility or discretion on the question of IVAs. In particular, cases involving those who are subject to IVAs must be considered by specialists as individual cases, and funding for such advice provided as a matter of course. This is not something that can just be done by a general lawyer. These are complex technical matters, and this issue is especially urgent for one of our clients, Ms. Elliott, who is facing the prospect of having to enter into an IVA, and who requires advice very quickly on how to proceed with her compensation claim. In relation to taxation, we've made a point in our written submissions that the £1,000 cap was unreasonable because a tax consultant would have to deal with matters of complex historical nature, which may very well be affected by an insufficiency of documentation. Mr. Chapman has said that, that this is not set in stone, and it's not an upper limit. We think that is something that we'd like you to record in your decision, if possible, sir, just so that that is there. There are likely to be difficulties where postmasters are pushed into a higher tax bracket due to receiving a lump sum payments. Other core participants have said that in their submissions. And we note that DBT, paragraph 21 of its submissions, is working urgently to address this issue. Mr. Chapman has given a proposal today that there be a sort of a form of for want of a better word, an indemnity by way of additional payments to those in the HSS scheme who aren't exempt. And we note that does appear, at the very least, to resolve this issue. But again, we need to have a decision made very quickly for the benefit of our clients. In order to, in respect of the issue of stigma for bankruptcy, I note what Mr. Chapman said this morning, that the advisory panel has said that bans are indicative only, cases will be decided on the merits, awards may be significantly higher, and if not agreed, there is a right to consideration by an independent panel. But this, nevertheless, is very important because stigma is an overwhelming issue for those of our clients who've been made bankrupt. It does appear to be in discussion stages only, and I hope that's not unfair. And so I would ask that you rule or that you recommend that there be a confirmed and concluded decision on this issue very possibly. And I've given an example of how many of our clients are still continuing to be affected by bankruptcy. I referred earlier on to Mrs. Palmer. She was she gave evidence in phase 1. She was prosecuted and acquitted at trial. However, the Post Office refused to restore her contract and she lost her branch. This led to her shop losing business, and eventually she borrowed some money from one of her children to petition for bankruptcy. She lost her home, moved into rented accommodation with her husband, and suffered significant stigma. I referred earlier to bailiffs putting her furniture out on the street. Her car was clamped in full view of her neighbours in public. She describes this as total humiliation. Although she was discharged after a year, the stigma has never gone away. She's still unable to rent property. She was rejected when she applied for a credit card after she received her interim payment. She and her husband wanted to go away on holiday for Christmas and wanted the insurance that a card can bring. She's also recently had to declare her past bankrupt status when applying for motor insurance. Furthermore, she has a telltale 6-year gap in her credit record, which would alert any potential lender, we say, to a formal bankrupt status. So the stigma of bankruptcy is very real for our client even today. Ms. Palmer lives in a tiny housing association property in an area where she says there are drug dealers. She's desperate to move, but can't borrow or rent property. And it's this situation arising from stigma which still continues to oppress Ms. Palmer and her husband. So we want some finality on the banding and the levels of compensation for bankrupt clients who suffer from stigma as soon as possible. And we suggest maybe this should even be a separate head of damage within the scheme. Stigma of bankruptcy for our clients never goes away. So I'll conclude. As set out above, as I've said, there are 3 main issues in relation to the GLO scheme. Firstly, the need to avert a further scandal through SPMs running out of time and being forced to accept derisory offers as a consequence of the GLO scheme August 2024 deadline. There's another related issue, of course. If a solicitor is required to advise a client as to whether to accept a low offer or have no compensation at all, that puts that solicitor in a very invidious position because it would be potentially negligent to advise a client that they should accept an offer which is derisory or substantially lower than what they ought to have claimed. We hope that our proposed solutions of the imposition of a timetable and perhaps more importantly the appointment of an independent overseer in the mould of Sir Anthony Hooper will do much to alleviate this very real concern. Secondly, we're concerned that many of our clients continue to live in desperate financial situations. We suggest that Chris Dawson's suggestion of a second interim payment would go a long way to resolving the plight of many. And we can see no reason why these suggestions couldn't be adopted and wouldn't work very well to resolve this issue. And finally, it's important that a degree of recognition is given to the fact that some of the worst facts may not be known yet and will be uncovered in future phases, and we say that the compensation regime and the compensation scheme should address these points. And as I've said at the outset, sir, it's very important that the inquiry continues to monitor this issue of compensation. So the Post Office Minister has given a statement and said, we will keep fighting for the postmasters and their families, and it is right that they will now receive full and fair compensation for the pain and suffering caused by this scandal. So that is an exasperating statement in the ears of our clients. From their point of view, what is needed in my submission for the GLO scheme to have any effect whatsoever and to be capable of resolving the very serious issues that it addresses is robust case management, and that is what we are proposing. The sentiments expressed by the Minister have not been borne out by the fact that there have been delays which cause our continued suffering to our clients, and that there is the fact, the unavoidable fact that the GLO scheme may very well time out. So can I just finally say something about restorative justice? We welcome what Ms Gallifant said today about the 6 meetings that have been arranged, but restorative justice is not about apologies. In the Grenfell inquiry, by way of an example, the bodies administering restorative justice appointed an appropriate advisor to consult with the victims. That is the sort of action that is needed. So if I could refer you to page 31 of our written submissions, we set out what we say a restorative justice scheme should involve. I won't read it out because of the time, but what we ask for is we ask for the Post Office to engage with Howe & Co on those very issues. In relation to...
so this is paragraph 132, yeah?
Yes, it is, sir, yes.
Yeah, fine.
In relation to compensation, we ask that the inquiry determines, in line with what's been held in the Effective Blood inquiry, that compensation under the schemes should be open to family members of those who've been affected by the Post Office scandal. And the inquiry has heard evidence in phase 1 that many family members became carers of sub-postmasters or mistresses whose health was affected by their parents' or family members' treatment at the hands of the Post Office. Many children of sub-postmasters suffered adverse mental health impacts as a result of stigmatisation of their parents. Other members of other family continue to suffer the financial consequences even today associated with having provided assistance to sub-postmasters who experienced shortfalls. So it's very important, we say, that the compensation which arises from this inquiry recognises that the Post Office's conduct impacted on whole families and not just the individual sub-postmasters who were targeted by the Post Office. And absolutely, very finally, sir, Ms Gallifant helpfully referred to an internal review in relation to unsafe convictions and a process that's being established. That, of course, is a welcome step, but we say that it needs to include the victims. Those victims need to be able to have input into that review, and they need legal representation to do so, because they may not agree with the decisions and the outcomes, and they need to have a right to be heard in that, as in all of the other schemes. So I'm sorry for going on for quite so long, unless I be of any further assistance than those in my submissions.
That's fine, thank you. Right, so it's very nearly 2 o'clock. How long would you like to take instructions, Mr. Henry?
Sir, could I ask for 20 minutes?
And approximately how long will you be having taken instructions?
Having taken instructions, sir, I hope very much that I will be no more than 30 minutes.
Right, fine. I think I'll remember that.
You shall. You shall.
And just so that we can be clear, Mr. Maloney, how long do you expect to be?
So I think I can make my submissions much shorter than the written submissions, given that what's been said.
All right,
And so I'd like
fine.
to keep them within 15 minutes.
So it looks as if we're still going to finish comfortably within a normal afternoon. So you can have your 20 minutes, Mr. Henry.
Thank you, sir.
Right. Everybody ready? The floor is yours, Mr. Henry.
Thank you, sir. We're all familiar with compassion fatigue. And here we are again, sir, compensation fatigue. You keep, as you say, banging on. One might imagine more satisfaction would be derived from bashing one's forehead repeatedly against a stone wall. Such is the frustration that any right-thinking member of society would feel. A sense of outrage, in fact, at the grotesque spectacle that occurs again and again, notwithstanding your best efforts. And you are, in one sense, being stonewalled, because you are always being assured that it's just around the corner. Great progress has been made. All best endeavours will be undertaken. And these are accompanied with emollient words and ardent expressions of disgust, and how everybody is fully supportive about identifying fault and making sure that nothing like this happens again. The leader in the Times yesterday, sir, reveals the reality. And you are familiar with the reality. And it may be presumptuous of me, but your patience and your ineffable courtesy, at times it appeared that even you seem to be, as it were, overwhelmed by the sense that you were again being kept at a distance, and those people who were destroyed by the Post Office, either through wrongful civil judgments or being forced to repay imaginary debts that never existed except in a flawed computer program, or being sent to prison, well, that they don't matter. But they do matter, and you know that. But the clock is running, and it is running down very badly. Now, on the 8th of December, I addressed you as follows, and you will find this, sir, in the coda to our submissions, which were submitted on the 6th of April. There are two issues. The first is the continuing and inexcusable delay in delivering compensation to the wronged, to the innocent, and that will include whether the awards proffered are even remotely approaching acceptability. The second, which is inextricably entwined with the first, is whether the Post Office will accept that it deliberately denied, obstructed, and delayed appellate rights, needlessly, unjustly, and wrongly prolonging the suffering of those that it had devastated either by civil judgments and bankruptcy or criminal convictions. That remains unanswered. and it does not augur well. We continued in paragraph 32. The second issue was a direct question to test the candour, integrity and remorse of the Post Office, and the continuing silence of the Post Office does not augur well for either disclosure or compensation. The question as to deliberate and tortious suppression of appellate rights was framed in the context of an additional head of damages. But there is silence. Now, sir, it was our concern that why are these poor people rushing into settlements, their lives having been destroyed for years? They have suffered huge financial insecurity, loss of earning power, loss of reputation. One of my clients, she does not mind me mentioning it, is facing eviction on the 6th of June. Mrs. Misra, unless she can muster 6 months' rent to be paid in advance. And yet, a number of these poor people, whether represented or not, it doesn't matter, are rushing into settlements which, as we saw from Mr. Maloney's submissions on the 8th of December last year, some of them were agreed on an irregular basis, where a global law firm had, as it were, it seems, failed to appreciate that there were additional heads of damages to which these claimants were eligible. And so, sir, the problem with this continuing lack of candour by the Post Office is that it is part and parcel of the disgraceful conduct that brings you and I here today with all of these other people who have suffered. It is part of that disgraceful conduct where they are continuing to suppress the truth. Only until you get at the truth that they, for years, knew about this and deliberately suppressed it and manipulated evidence and procedure to their advantage, will you arrive at proper quantum? Because there is, for example, the wrongful bankruptcy, and again, your ingenuity and creativity in asking Ms. Addy to address those issues, and we thank you on behalf of the core participants for that. But there is also the tortious abuse of process as well. And yet, those whom I represent, certain of them who have put in claims, have been told, well, you're not getting that. You're not getting abuse of process. Nobody else has. The fact that they have got away with it with other people is no answer to depriving our clients of rightful and proper compensation. Or is it because they are standing on what really is the most unfortunate settlement, whereby for absolutely nothing, for zero consideration, those convicted innocent people in the group litigation forfeited every other claim except for malicious prosecution at the insistence of the defendant? How bizarre was that? Driving a wedge, as it were, between the claimants in the group litigation. And so, sir, until we get at the truth, then I'm afraid this exercise in which we are involved, in which you have played a very important role in trying to keep it on track, I regret to submit will be hopelessly derailed. Because what will happen, and I hope that I'm wrong, is that we can see in a few years' time, people will come and they will say, well, we were had over, we were trounced, we were taken advantage of. This settlement is a travesty. this compensation that we've been awarded is utterly unfit for purpose. And of course, apart from the GLO scheme, who is nominally in charge of those other schemes? The Post Office, aided, advised, assisted, dare I say, abetted by Herbert Smith Freehills. Now, I submit what I do now, what I now submit, I do with care and forethought and deliberation. On the 4th of October 2022, Mr. Shelton, King's Counsel, together with his learned junior, Mr. Mertens, put in written submissions on behalf of UKGI. The Pahiti reference, or the relativity reference, I should say, is subs, then 6 zeros, 6. And this is what you were told, sir. You were told in paragraph 2014 that the board met to consider the issue of recusal in, obviously, Horizon. Mention is made that Lord Neuberger had been asked to provide an opinion which was strongly in favour of making a recusal application. UKGI's General Counsel, the shareholder of the NED, played no part in the board's decision-making on the recusal issue. The other member, the permanent secretary, recused himself from the decision, and so on and so forth. As we know, that recusal application was made, it was dismissed, and the subsequent application for permission to repeal was refused. But it is, in our respectful submission, a seminal episode in the whole saga of injustice. And may I briefly develop why? And its relevance to compensation will therefore be obvious. Because we all have heard, and in the same way that people repeat apologies, I suppose, on behalf of the core participants, I repeat words such as egregious and iniquitous, turpitude, etc., on behalf of the Post Office's, characterising the Post Office's conduct. But what can be in no doubt, sir, is that the Post Office knew that the CCRC was riding on the back of the Horizon litigation. That was apparent to the Post Office. If the Horizon litigation had foundered, if it had resulted in a defeat for the claimants, or a miserly settlement, perhaps even more miserly than the one that was eventually obtained after the funders' costs and interests had been deducted, etc. But if the Post Office had succeeded, again, sir, you and I, together with all of these other people, would not be here. But worse, who can say what would have happened to the CCRC referral? And so, therefore, the Post Office was playing for very, very high stakes indeed by attempting to recuse Mr. Justice Fraser. Well, in paragraph 215 of the submissions of the UKGI, it was then stated, accordingly, Mr. Justice Fraser continued to hear the Horizon Issues trial. UKGI provided the Secretary of State with an update on the current state of the litigation on the 12th of April 2019, including the fact that following intervention by the chair and the shareholder NED, the Post Office had refreshed its legal team, whatever that means, including internally reorganising its legal team and replacing its general counsel and employing a new firm of solicitors, HSF, to revisit the approach to the litigation. But, sir, we know that however it came to be, and that submission being made and submitted to you, sir, by none other than leading counsel and highly reputable junior, that was wrong. Who knew what when, who conned whom in respect of paragraph 215 is not really for me to say. But what is clear is that there was an attempt, deliberately or inadvertently, to mislead you. Everybody can read. These documents are circulated. There was no correction from the post office, no correction from anybody on the post office team, so far as I'm aware. If there has been a correction at the time, saying, I'm terribly sorry, Herbert Smiths were directly involved in advising us on the recusal, then I will withdraw what I have just submitted. These are public documents. They've been published and circulated, cross-served. There has been no correction. And so, sir, here you have Herbert Smiths advising on the recusal, advising the post office and witnesses in respect of this inquiry, in which the recusal application will be a seminal moment in phase 4, and also supervising certain of the compensation schemes. One of them having to supervise it because the original hard bargain they drove, ruthlessly drove on behalf of their clients, consistent with their duty to their client, was completely unfit for purpose. It's a hopeless conflict, but what concerns us particularly, sir, is the fact that unless you get at the truth, then there can be no proper sum awarded in compensation. And more importantly, sir, because as Miss Skinner said to you many, 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 many months ago, no amount of money can compensate us. But what we do owe, we owe the dead. And there are people, as we sadly know, who have died, either by their own hand or through just the passage of time. We owe them and their families the truth, and those who have survived this catastrophe. And we respectfully submit that this compensation, as currently supervised by Herbert Smith on behalf of the Post Office, just will not do. Because if they are involved in the recusal, which is a massively aggravating feature of this campaign of wrongful conviction, this campaign of injustice, perhaps the worst to be seen in modern times, then you will inevitably fail, sir, despite your best efforts.
Can I just see where the logic of what you are submitting is taking me? Because I understand full well your submission that it is necessary to get at the truth in order to properly compensate people. I follow that.
Yes.
But in terms of this inquiry, getting at the truth means, in effect, hearing all except possibly the last phase of the inquiry in terms of what you are now talking about. And it means me taking, no doubt, inevitably, some months thereafter in order to formulate my conclusions upon it. So that the logic of what you're saying, and I'm not saying this in any critical sense, but simply to understand where we're going, is that no proper compensation in the sense of it being reliably founded on evidence, on all relevant matters, can be paid for another 12 months or more. Is that fair, Mr. Henry?
Well, sir, the way I'm going to dodge that bullet is to endorse Howe and
We've
Co.'s...
had passing the buck and now we're dodging the bullet.
Well, there we are. I'm endorsing Howe and Co.'s approach, because one of the mischiefs of rushing into settlements and the financial pressure that these disadvantaged and marginalised people suffer, living in poverty on the breadline, is that they're forced to accept something without the truth being fully exposed.
And Mr.
So-
Henry, that would be awful. Let me make that
Yes,
plain.
yes. So
But we are on the horns of a dilemma, as I see it, in the way we're trying to organise this.
not so, sir, if we endorse the Howe and Co approach, which is that there are structured interim payments where if you can show that you are likely to receive substantial damages, and those Mr. Marshall has the privilege of representing, and in this inquiry I have the privilege of representing, are deserving of very, very considerable damages, well then they can make applications for their reasonable requirements, and they can provide reasonable evidence of the strength of their claim. And therefore they can receive, without any financial pressure driving them into an unjust settlement, they can receive proper, structured interim payments. And it's also an integrity test as to whether government and the post office really mean what they say, because it will protect people from being forced into a settlement. Unfortunately, sir, whether this is happening up and down the wicket, I do not know, but it looks like from the submissions that were made last year that a number of people are settling because it would seem that really they have no choice but to settle. And they may be settling for a mess of pottage as opposed to a proper award. And that is the concern. Now, can I just develop this? Because very important to answer your question. So it would not mean that the call participants who are eligible do not receive any money at all until the very end, but they receive proper structured payments, and that the matter can then be, as it were, set off at the very end when the final award is made. At the moment, for example, further financial pressure is being exerted inexcusably on these unfortunate, weak, poverty-stricken individuals because, for example, interim awards are then deducted when there is a payment of towards general damages. And so therefore the post office, as it were, gives with one hand and then takes away with the other. So it helps, no doubt, the post office's liquidity, or rather the Treasury's liquidity. But one might think that the Treasury has got a better way of coping with cash flow problems than people who've been living on the breadline or living way beyond the lifestyle that they ought to have had for years as a result of the post office's misfeasance. So why, as it were, make the deductions? Why make the deductions that the post office insist? In other words, you'll get your 163,000, but then as soon as a stage payment is made, that 163,000 is clawed back. So in other words, you get the 200,000, but then there is a clawback. it has been described in correspondence, forgive me, I'm sure that Miss Gallifant will not be amused, but it's been described as spiteful and vindictive. And that's what it is, because it is done deliberately, knowing that the other side do not have the means to withstand it. They're forced between the rock and the hard place. And then the other argument, of course, is that there were ex gratia payments for the wrongly convicted. Ex gratia. It was charity. Now the Post Office is saying, well, the charitable donations that you received from the other claimants in the GLO, you having forfeited everything except for your claim for malicious prosecution. So there's charitable ex gratia payments. They've got to be deducted as well. Now, that's a strict matter of law that can be litigated, but in good faith, the Post Office should not even begin to countenance advancing an argument like that. There was no consideration given by the Post Office for those claimants who had been the subject of wrongful conviction, surrendering all of their claims, surrendering absolutely every single one of their claims, but for malicious prosecution. There was no consideration given at all. So now, after the event, the Post Office, seeking to deduct the ex gratia payments of the other claimants, again, we respectfully submit it's low behaviour. And what the Post Office should do is that the Post Office should, even if it can't reconcile itself to the arguments that have been properly advanced, the Post Office should say, well, we'll treat that as it were, ex post facto consideration admittedly given by the claimants for you surrendering your claims. So you can keep that and we won't deduct it. So that would be my argument, sir. You've got to relieve these people of the financial pressure that they're being put under, because they are being driven, we respectfully submit, quite deliberately, to settle below the quantum that they rightly deserve. This is why we were asking for transparency. Some of my learned colleagues prefer not to have transparency in this matter, everybody to their own. We can only respectfully submit that in a case or a saga, and I don't trivialise it by calling that, involving so many secrets and discreditable manipulations behind the scenes, the lack of openness and the lack of transparency again gives rise to potential injustice. Because if this awful episode in English legal history means anything, it means that if you can just get a group of people to coalesce who actually know everything about each other's cases, then you might have a chance against this behemoth or this monolith. You might just have a chance of getting a shot at justice. But if you're dealt with individually and separately, you're battered away or you're swatted like flies. So those are our submissions on the matter. I respectfully submit that it's not destructive, what I am arguing. I'm basically trying to answer the point that you made in your 9th of January report on the matter, your statement, forgive me, sir, where at paragraph 52, you were responding to my learned friend, Mr. Steen, King's Counsel. And at paragraph 51, Mr. Steen case, he invited me to recommend that all 3 schemes should be subject to overall supervision by a person or body who is independent of Bayes and or Poll. and then I omit words. There are 3 schemes in various stages of their development which are functioning in substantially different ways. In my view, it would not now be possible to appoint a person or board to supervise all the schemes without there being a significant risk of substantial delay as a result. In relation to all schemes, that would be very undesirable. In relation to the GLS, however, such delay could be disastrous, and we respectfully endorse that, sir, so far as the GLO is concerned. But given the untenable position of HSF in this matter, because the recusal issue is central to the question of misfeasance, whether, for example, there might have been joined up thinking between the criminal litigation that was in contemplation in the Court of Appeal, and the civil litigation, the litigation subcommittee. But it's absolutely critical to the issues that you are required to investigate. And if that isn't a conflict, and if they cannot see that it is a conflict, then one respectfully submits, well, they are so purblind that it's even more dangerous. And that affects, again, disclosure. So that is why, sir, somebody would have to come in and they would have to review the awards already made and also the conduct of the schemes going forward. And we make that submission with regret. But in fairness, last June, when we were making submissions to the inquiry, we alluded to the issue of conflict and that ordinarily we would therefore object, but for the necessity to get these matters processed without undue delay. But at that stage, we were not aware of HSF's involvement in the recusal. That now being apparent, and the very, very unfortunate submissions that were made to you on the 4th of October by no less than UKGI itself, there is, in our respectful submission, very considerable cause for concern. I can put it bluntly. Why does the Post Office not want to countenance abuse of process? Why will they not answer the questions put to them on the 8th of December? Because HSF wasn't a new broom. HSF was part of the problem. It was, as it were, an oily rag that tried to tarnish the reputation of the judge. Deeply implicated. That's the problem. Why don't they want to countenance abuse of process? Because they would have to disclose all of that. And that is, in our respectful submission, utterly unconscionable. And that is why, sir, with regret, we have to make the submission we do, so far as HSF's continued involvement in those compensation schemes.
Thank you very much, Mr. Henry.
Sir. Sir, I wonder if I may ask the indulgence to respond on one point of fact. I didn't want to do Mr. Henry the discourtesy of interrupting him mid-flow. It suggested that someone should have corrected or objected to UKGI's submissions. We don't and didn't, for the simple reason that they are based on a contemporaneous document, which is BAYS 5071. I don't ask you, sir, to turn it up, but can I just make it clear that that document does not say that HSF was involved in the recusal application. The inference that Mr. Henry seeks to draw from it is completely different from what the document itself says. I wonder if I might simply give the factual timeline. The decision was taken to apply for recusal of Mr. Justice Fraser on the 20th of March 2019. On the 21st of March, the recusal application was issued. On the 3rd of April, it was heard before Mr. Justice Fraser. On the 8th of April, HSF made a presentation to the board as part of the proposed refreshing of the legal team referred to in the UKGI submission. The recusal application was heard and refused by Mr Justice Fraser on the 9th of April. It was thereafter that HSF were instructed. So they were not the people who advised on making the application. It is a simple point of fact. No doubt you will look at all the relevant documents in phase 5,
Yeah.
but it is important simply to put that down as a marker at this point before you consider Mr Henry's submissions.
I'm very grateful to Ms. Gallagher. I'm not sure if I need to withdraw it there because there
Well,
is.
I'm not going to let this continue. The facts surrounding it will be investigated.
They will. Yeah.
And so that's sufficient for these purposes.
Thank you, sir.
To what extent your recusal point is necessary for your more general point, I will ponder.
Could I just mention one thing, and I promise you, one sentence.
Really? One sentence, Mr.
One
Henry?
sentence. If they were not formally instructed, were they acting as it were below the parapet? Question mark.
All right, that's enough now. That's enough. That's enough. There has to be some decorum in these proceedings. I like to be informal, but there comes a line and we're about to cross it and we're not going to cross it again. All right? Mr. Maloney, are you ready?
Sir, I make submissions, as you know, on behalf of Hudgell
Yeah.
Solicitors, core participants. Hudgell Solicitors represent 125 claimants under the historical shortfall scheme. After this morning, 73 persons whose convictions have been overturned. The 2 did have their convictions quashed
Right.
this morning, sir. And then 4 persons involved in the group litigation scheme. We provided written submissions, sir, in respect of the issues you asked us to address, and I'll take each of those issues in turn briefly, if I may, sir. So firstly, bankruptcy. In respect of the opinion of Miss Addie King's counsel, it seems that the only point of contention there is, in respect of her advice, is the figure of £300,000 as the starting point for the stigma damages for bankruptcy.
Well, if I can use you as a sounding board, having heard everyone apart from you now, and possibly Mr. Beer, there's the £300,000, which is a point of contention,
Yep.
and there's what to do about more.
Indeed.
And everything else seems to be, as a matter of legal principle, agreed.
Indeed, sir.
Right.
Entirely. And I'll come on to Hudgell's position in relation to Moore's in due course. But, and as you said, sir, but firstly, it was dealt with by Miss Gallifant in relation to the HSS, but it also applies to the group litigation scheme.
Yeah.
And as you said, sir, there is a potential dispute resolution process in HSS and the group litigation scheme where that point could be taken and resolved. But we wonder, sir, in the interests of consistency and in the interests of clarity, whether it might be useful, and we put this out as a suggestion, if there was a further early neutral evaluation where that point could be adjudicated on by Lord Dyson or some other appropriate person, but it would be preferable if it was Lord Dyson because he's now familiar with the cases and issues. As you know, sir, in the early part of 2022, there was some distance between Post Office and the Hudgell clients on the appropriate levels for non-pecuniary damages. And the parties agreed to early neutral evaluation in order to, and this is the point of it, to secure some sort of realistic assessment of the damages that would be recoverable if the courts were required to adjudicate on this, because that's what's important in these cases ultimately, if these cases were to not be settled but go to litigation. Lord Dyson, the former Vice President of the Supreme Court with enormous expertise in the area, was agreed upon by the parties, not imposed by one party, agreed upon by the parties. And as is said by Howe & Co in their written submissions, the ENE has proved valuable in facilitating the settlement of the non-pecuniary claims of their clients, subject to, if I might call it in this, sir, the GLO ex gratia clawback, subject to that concern, and it's proved valuable in settling the non-pecuniary claims of the Hudgell claimants. Now, I'd suggest that issue of the proper stigma damages for bankruptcy is one of three issues, really, that have become apparent between the parties during the course of today's hearing. The second one is one I've just referred to, the ex gratia clawback. And the third one is whether, and Mr. Henry has just mentioned it, whether the tort of abuse of process could make any difference to the awards for exemplary damages. It may be that an early neutral evaluation could deal with all three of those points. It seems to me that they're all susceptible to early neutral evaluation. And it could be just one advocate on the part of all of the core participants. We would be happy to step back to leave that to others. And there's no reason why it couldn't take place very soon. The issues are relatively confined, and it could be decided very soon before the summer break. And the decision of Lord Dyson, or whoever else it may be, could then be made available to the core participants, and the parties could get on with things as they choose, but with that background. As I say, sir, it's only a suggestion, but experience tells us that it's been very useful.
In the early days, by which I mean probably at the time of the first hearings about compensation, there was some, and this is my word, so nobody should read anything into it in particular, it's just a description, but some disquiet that some of the people affected by the early evaluation scheme were not party to all its terms. If you recall, I think originally it was a scheme born between Hudgels and the post office, and there were obviously other people who were not represented by Hudgels. Your suggestion, I take it, now carries with it the suggestion that all representatives of convicted postmasters whose convictions have been overturned would be party to this evaluation.
Not only all who have had convictions overturned, but all who are part of the HSS, part of the GLS, Group Litigation Shortfall, all could be involved because they are points that apply to each of the schemes, as it were, and they are self-contained points of law with application in a case-specific way to each of the cases which would be considered.
And this is a purely practical point. We're not running into the difficulty that in respect of all the people in all the schemes, there are simply too many lawyers involved to make this practical, are we?
We'd be prepared to step back, sir. There are points which can be made. They've been rehearsed in submissions already. We'd step back. I don't know what Mr. Steen's
Well,
position
I'm not
would be.
asking for
Absolutely.
instant answers. I'm exploring your suggestion, Mr. Maloney, that's all.
In our respectful submission, sir, it only needs one to take the arguments. It was agreed on, as far as the core participants are concerned, if agreement be reached on the appropriate person to take the arguments, and we would step back.
Okay.
So that's the general point in
Yeah.
relation to Miss Addy's opinion. If I could now turn to the specifics of bankruptcy in relation to the schemes. Use that shorthand. And firstly, the overturned convictions. Today, matters are resolved so far as the issue of bankruptcy as it appears in overturned convictions for Hudgell claimants. We've heard from, you know, sir, that, and this has been the case for some time, that the official receiver has relinquished all interest in overturned conviction cases for those represented by Hudgels. And we heard from Mr. Chaplin this morning about the situation with Moores. We'd already resolved the position with Moores by essentially the three cases, the Hudgell cases that involved bankruptcy with Moores. Payments were made to settle things with the trustee. And those payments were required because the persons affected had assigned a proportion of the benefits of their claims against Post Office to the trustee as part of the JLO settlement. We're grateful for the indication that those payments will be reimbursed in full, and that puts an end to it so far as Hudgell's clients and Moores are concerned. So far as the historical shortfall scheme is concerned, This is more complex, but again, some encouraging progress is being made. And I hesitate to use that term representing core participants, but we are actually making progress. The insolvency expert instructed by Hudgels is working closely with the official receiver to devise a formula for dealing with cases involving bankruptcy where Post Office or POCL was responsible for the bankruptcy. And the proposal, which is in fact the same as I gave when you asked me at the December hearing, sir, is that it first establish what's needed to pay off the bankruptcies and from there gross up the proposed settlement to ensure that the claimant is restored to the position they would have been in but for what was occasioned to them from Horizon Unreliability. And there seems, sir, to be broad agreement as to that approach, and things are moving forward in that way. Additionally, sir, interim payments are now being made for losses which it's agreed could not form part of the bankrupt estate, and that's for the general damages. And they're being made whilst the complex picture around each bankruptcy is analysed and resolved. And it is a complex process, sir, as you can imagine, because the official receiver needs to look at the records from some time back in order to establish who they need to approach and so on. At paragraphs 17 to 19 of our written submissions, we identified concerns around the payment of damages for bankruptcy stigma in these cases and what could be done to improve the position of Mr. Duff and others. There have been discussions since then around the provision of further information, which have clarified matters, and we expect to make progress in improving their position very soon. But it does have to be very soon, sir, and we're conscious as their representatives of a duty on us and on others to make sure that this is done. As we've said in each of these compensation hearings, these are some of the most vulnerable claimants for obvious reasons. Not just Mr. Duff, one of the claimants who's recently instructed Hudgels solicitors, and Mr. Ranganathan Kumar. And of course, whenever I use a name, sir, there is consent to my using that name within these proceedings. Mr. Kumar received a 6-figure offer, but because of the nature of the bankruptcy, only received an interim payment of £4,000. He's now facing repossession proceedings in respect of his family home at the end of May, despite the fact that he's owed 6 figures in terms of damages at least on the offer that's been made. So we're having to work very hard to try and resolve that situation, sir, and we hope, following the discussions that we've had today and prior to today, that we will be able to do that. That's it on bankruptcy, sir. Safe to say that many of the advances, and there have been many so far as Hudgels claimants are concerned, many of the advances around claims involving bankruptcy have followed the airing of these issues in the hearings that the inquiry has devoted to compensation, sir, and for that we are grateful. Now, sir, taxation. Sir, for many months, as is reflected in our written submissions, Hudgels solicitors have been requesting that government provide a tax exemption to bring the HSS into line with other schemes. We've now heard from Mr. Chaplin today that something's going to be done. We don't see how that tax exemption, in just a simple tax exemption, would advantage HSS claimants over the other schemes, but we are at least encouraged that something is to be done. But we echo very respectfully what you said, sir, that it needs to be done sooner rather than later, so far as those claimants are concerned. You also asked, sir, for a factual update on the historical shortfall scheme and overturned convictions. Taking each in turn, historical shortfall scheme, Hudgels represent 125 claimants. Those include 26 bankrupt claimants and 12 out-of-time or late applications, which I know are matters of concern. There are some encouraging matters to report. In previous submissions on compensation, we explained how the lack of interim payments in HSS cases impacted claimants, obviously. We're pleased to say that interim payments are now made on a regular basis and at a level of up to 80% of the overall offer. And there had been a delay in agreeing a cost matrix, including provision for expert fees. However, that delay now appears to be resolved, and a matrix similar to that, provided for under the group litigation scheme, but based on reasonable cost and not fixed fees, is close to being formally adopted. Hudgell solicitors, as you know, sir, had previously expressed concern in July and December of last year that expert evidence, such as a medical report, was not available to HSS claimants due to lack of funding, and the current position now, sir, is that all cases are now able to benefit from appropriate analysis by relevant experts. It's not all rosy. Despite weekly meetings between Post Office and Hudgell's, not one of the 120 cases, plus cases, is currently capable of settlement, final settlement. They are cases of complexity which require significant investigation and negotiation. And inevitably, sir, I hope you'll forgive me for repeating our previous concern, which in fact Mr. Henry has just echoed, which whether or not the earlier cases where claimants were prematurely settled at a level which did not reflect their true value. We take into account what's been said about whether or not they might be the more simple cases, more easily resolved, and we of course realise that the inquiry will be returning to this topic in stage 5, and so we say no more about it at this stage. But it's hoped that the 125 cases will be resolved this year, but we can't really guarantee that, but that is our hope. In submissions on compensation in December, sir, we remarked on the delay of the HSS in deciding whether late applications would be accepted. There are 12 for Hudgell's, 4 have been accepted, but there are 8 that are still outstanding, sir. We've listened to what's said this morning, but there are 8 of the 12 that are still outstanding. Finally, sir, in this section, many of the concerns that were expressed in our July and December submissions, omitting heads of damage and loss, issues around burden of proof in the absence of documentation, limiting loss of earnings to 26 months, and the settling of cases without advice. Those problems remain of concern to us, sir, but, and in fact are highlighted by others today, but we're conscious that they'll be returned to in stage 5, and so we say no more. So far as the overturned convictions are concerned, since the December compensation hearing, there's been significant progress made in respect of non-pecuniary loss claims. The current position is as follows. 53 have been settled and paid. The total was 15 at the December hearings. 2 are subject to negotiation following the making of offers, and 12 are yet to be presented. Now, those largely concern recently quashed convictions, but there are also clients who would prefer to wait until the end of the inquiry before settling their claims, which demonstrates that, contrary to what's said by some, nobody is bound by the early neutral evaluation. Clients are free to accept or reject the early neutral evaluation, and indeed free to proceed to litigation if they wish to. So, sir, and that residual potential to proceed to litigation is very important to all of our clients, sir. And so some have decided to, as it were, delay the decision on settlement until the inquiry reports, as is their power. The submissions on behalf of Howe & Co. reiterate, as we said before, how useful the ENE has been to their position, and it has been so far as the Hudgell claimants are concerned. So far as the pecuniary loss claims are concerned, 2 cases have been settled, 4 are in negotiation following offers, 3 have been submitted in full with offers awaited, and the remaining cases are yet to be presented. Now, that delay is nothing to do with Hudgell solicitors, nor indeed the claimants, we say, sir. You'll remember, sir, that in Appendix E to our December submissions, we provided details of the delay in the progress of the 4 cases which were being used as a pilot for future cases. It was expected as well that those cases would provide a basis for principles proposed by Post Office for dealing with future cases. We've included in our written submissions the further delays that happened after December. And I won't go through all of those, so you have the details in the written submissions. But in case 1, the schedule of loss was submitted on the 20th of June of 2022. That's fully particularised. And there was there's a period of 5.5 months between the last evidence being submitted and an offer being advanced. In case 2, again, schedule of loss submitted on 20th of June 22, and there was a period of 5 months from the last evidence being submitted to an offer being advanced on the 2nd of March of 2023. Case 3, schedule of loss submitted on the 5th of August 2022, period of 5 months from the last evidence being submitted to an offer being advanced. And then case 4, schedule of loss submitted on 20th of June 2022, a period of 3 months from the last evidence being submitted to an offer being advanced. And for months and months, Hudgels pushed for draft principles for the resolution of claims. They were finally received from Paul on the evening of Friday, the 31st of March 2023, so just a week before the written submissions were due in relation to this compensation hearing. And we hear that there are more coming. We're considering the proposed principles and will revert expeditiously, but we note that the principles do not preclude any head of loss from consideration, nor have any been precluded during the course of our work so far. And moreover, they contemplate the recovery of joint losses with partners and others, which is important. We'll be looking as part of the discussions to explore how far that approach will be extended. For example, will it cover non-pecuniary losses of immediate family? But obviously that's something to discuss as we move forward in relation to those principles. But the delay from Post Office in making offers in the pilot cases and providing proposed principles for dealing with the remaining cases has meant that more pecuniary claims have been unable to be submitted. There are also delays in case-specific disclosure, which you've heard about, sir, from others. It's still incomplete in many cases. We've raised this in previous submissions, and it's reflected in the experience of Friths in the GLS scheme as set out in section 2 of their letter. And indeed, those delays have been acknowledged this morning. But nevertheless, considerable progress is being made, and we can repeat what we said at paragraph 40 of our December submissions. There is no reason why these claims realistically will not be resolved during the course of this calendar year. And so, sir, those are the, that's the update in respect of the overturned convictions. Finally, the factual progress update on the implementation and administration of the group litigation scheme. Hudgels only represent 4 claimants in this, each of whom is a relative of a client who pursues a claim pursuant to an overturned conviction. So I won't take too long. There's a general concern, repeating what we said in our December submissions, that in the absence of a significant escalation of resources for the panels, then the complexity of the cases to which this scheme is devoted precludes any prospect that the full and proper compensation will be paid by August 2024. And as been said, the guidelines and tariffs for this scheme have recently been issued. Widespread concern about those guidelines and tariffs have been expressed. The provision that's attracted most public attention, namely the tariff for stigma damages, was not the subject of any discussion with claimants' lawyers. We're grateful to Mr. Chaplin for the acknowledgement of that during the course of the morning, but we would ask that if there is any further decision of that nature, that there is consultation going forward, so that some input can be given. So to conclude, sir, in preparation, we've spoken to approximately 200 clients for this, and these submissions reflect the responses we've received. Our clients really are rightly concerned about delay. That delay has not been on the part of them or their legal representatives. And each time that the inquiry calls for submissions, we've been able to identify delays in this process that have not been the fault of the clients nor their legal representatives. We've included, sir, within our written submissions, and I hope you'll just indulge me just for another couple of minutes, sir, that comments from some of our clients, that Barbara Atkins says that she feels like she spent the last 20 years of her life trying to prove herself, from in the early days explaining on CVs when employers asked for explanations of why I lost the post office, trying to explain over and over that I'd done nothing wrong, but no matter what I say, there's always an element of doubt on their faces. Why is it delay after delay, even after the result of the public inquiry? It only adds up to victims more misery, anxiety, confusion and uncertainties and more nervous breakdown. And that's a reality, sir. That is a reality for these claimants. And Margaret Smith, whose brother died, she said that the unacceptable amount of time it took to process his and others' claims. I wrote to the Historical Shortfall Compensation Scheme when John became ill, as he wasn't looking at his post, etc. So I lodged a power of attorney so they could respond with me too at John's request. That was around April 21. I told them John was ill, but it still took over a year to process his claim. They could have offered him an interim compensation then, as he was very short of money, and it would have made his life less stressful and more comfortable. It would most certainly have given him comfort, not just to get compensation, but to get a formal recognition for himself and his family and friends that the post office and not him were at fault. It's an injustice upon an injustice that they've dragged this out so and not thrown more resources at sorting it out for claimants. The other issue, sir, which exercises our claimants is that post office are dictating the narrative of this compensation process in the way that they have with previous schemes. And that's why the last resort of going to the courts is so important to them. But they remain as well concerned that Post Office has not accepted liability for what's occurred. And examples of that include Mr. Trousdale, Chris Trousdale, who's here today, who says that the Post Office's ongoing failure to admit liability is actively and purposefully perpetuating the harm and suffering of myself and other victims on a continued daily basis. It's prolonging the healing process and delaying the start of what will ultimately be a long recovery. I need to see restorative action from the Post Office. How can I consider an apology and start to move on when Post Office is still refusing to admit liability? I cannot put into words how excruciating and exhausting it is to have to keep paying mental anguish as a currency of dealing with the Post Office. They seem to think we have an unlimited capacity for mental distress. We don't. And then Jane Kemp, my view is that the Post Office needs to accept that the issues caused by the faulty system had a direct impact on the lives of many sub-postmasters and their families, and the ongoing process to agree a fair settlement is just further stress and misery when we've not done anything wrong. And Jasvinder Dosanjh says that the offer has been covered by the caveat without prejudice, which I understand is probably standard practice in these matters, but it also demonstrates that they're not serious about righting past wrongs. There is concern, sir, about something that has been raised today, that the absence of the admission of liability is preventing some from coming forward to address what has happened to them during the course of their convictions, because they fear for what might happen to them during the course of any claim that they take. And so, sir, those are our submissions, and thank you for the opportunity to present.
Thank you. The only other person who is potentially likely to speak is Mr. Beer, but I'll just look at the transcriber for a moment. Mr. Beer, first of all, are you going to say something?
Yes, in 10 minutes.
In 10 minutes. That's fine. Over to you, Mr. Beer.
Thank you, sir. You and the call participants know that in the last 3 hearings about issues concerning compensation that you've held, we as your counsel have not submitted to you that you should draw any particular conclusions from the material before you. This is partly because we do not understand our role generally to be to urge conclusions upon you after any evidence has been heard. And moreover, in relation to compensation issues, no evidence has yet been heard. That must await phase 5. On this occasion, however, in the light of the way that matters have developed, we felt able to isolate a range of issues which we suggest may benefit from consideration by you for inclusion in a further interim progress update or statement, or indeed in an interim report issued under Section 24(3) of the Inquiries Act 2005. As you know, sir, we'll be hearing evidence on compensation in phase 5 of the inquiry, which is likely to be in the late autumn. For reasons already canvassed before you, there can be no further delay here in relation to some of the issues that have been canvassed. Compensation relates to wrongs done many years ago, a decade or even decades ago. We're 2 years on, almost to the day, from the decision of the Court of Appeal, Criminal Division. Every day, week, month and year that passes further reduces the possibility of the achievement of the stated aim of the compensation process, namely of putting the wronged back in the position that they would have been in had the wrongs not been done to them. The issues that we have identified are all ones where it's not necessary, in our view, to hear oral evidence before making an interim report. You have a sufficient body of written material before you. You've identified to those properly interested in the subject matter the possibility of your making an interim report, and you have received extensive oral and written submissions on the issues. I should say briefly that the benefits of making a formal interim report under the Inquiries Act 2005, as opposed to producing a progress report or a progress statement, include the following. Firstly, such a report would stand in distinction to the progress reports and updates that you've made to date. It ought properly to be interpreted by those receiving it and by those to whom any recommendations in it are addressed as representing an escalation in the seriousness with which you view compensation issues. Secondly, by Section 26 of the 2005 Act, read with Section 25.1 and 25.8, any interim report that you issue must be laid before Parliament. Although there is no requirement under the Act for the government or for those to whom recommendations within a report are addressed formally to respond to such recommendations, the long-standing convention is that they do so, and that they do so formally, not simply by taking action or not taking action, by stating whether they accept your recommendation, and if not, why not. Thirdly, the use of the facility of making an interim report and the convention that I've just mentioned may be particularly useful in the case of any recommendations that you make that touch on the GLO scheme, where something of a guillotine is in operation, the operative date being the 7th of August 2024. This is because the inquiry itself will have a limited life, and so you may consider that it's time to use the formal powers and mechanisms that are open to you whilst you can. So the 4 areas which I suggest respectfully could properly be amongst those which you consider are as follows. And I should stress this is simply a list of 4. You've heard, by my reckoning, some 36 or 37 suggestions today. Firstly, you should...
I've lost count, Mr. Beer.
Yes. First, you should consider whether to recommend to the department that it should apply to the court for a direction pursuant to Section 303 of the Insolvency Act 1986 before final compensation payments are made in the GLO scheme. That GLO scheme payments do not vest in the trustee in bankruptcy. And that secondly, the department should undertake to pay the reasonable legal costs of any sub-postmaster involved in such proceedings. You've heard and you've seen that it's Catherine Addy's opinion that such payments do not vest in the trustee in bankruptcy, paragraph 62 and 63 of her opinion. Another insolvency practitioner took the opposite view, affecting 16 cases. And Ms. Addy has suggested that the department could apply to the court under Section 303. The department said in response in its written submissions at paragraph 16 that it was, quote, considering the position. You may consider that to be rather weak and non-committal. Today, the department has said that it allowed time for Moores to respond to Ms. Addy's opinion. That opinion was published over a month ago. You may consider that this issue has gone on long enough. Secondly, sir, I was going to submit that you should consider whether to recommend to the government that it should exempt payments under the shortfall scheme from income tax, capital gains tax and national insurance contributions, just like those payments under the OHC and the GLO schemes are, highlighting the consequences of the current arrangements and the difficulties that they present to the average sub-postmaster. But in the light of the announcements made on behalf of the department today, for the first time, there's no need for me to make a suggestion of such a recommendation, because it appears the department and the government more widely have taken a decision to address the issue differently by making payments to sub-postmasters in respect of tax. But this is a matter which you may wish to review within a set period, a number of months now, i.e. the operation of the department's new tax scheme to address problems created by the HSS. Third, you should consider whether to recommend that the government should exempt payments under the HSS and the GLO scheme from an inheritance tax. This isn't something that's been developed in any of the oral submissions that you've heard today, the inheritance tax issue. You know, sir, that Regulation 5 of the 2023 regulations provides that OHC compensation payments, but not GLO scheme or HSS payments, are exempt from inheritance tax. There's an attempt at an explanation of this difference in tax treatment in paragraphs 22 and 23 of the department's submissions. I summarise. The explanation is OHC claims are principally about non-pecuniary loss, whereas GLO scheme and HSS claims are generally focused on pecuniary loss. And secondly, that had sub-postmasters in the GLO and HSS continued in the financial situation that they were, they ought to, then their estate would have been subject to inheritance tax in due course. You'll wish to consider whether either of those explanations pass muster for the distinction in treatment. And I would add that given the large number of sub-postmasters who are entitled to compensation have sadly passed away, including recently, this isn't just a dry tax issue. It's a real issue of substance that will have a real effect on real people. Fourthly, you should consider whether to recommend that first, the department must promptly promulgate a timetable that will deliver fair and reasonable compensation for all applicants under the GLO scheme before the 7th of August 2024. That secondly, that timetable should be published. Thirdly, that the department must put in place sufficient resources, including by making appropriate funds available to both the Post Office and to applicants to enable the published timetable to be delivered by the 7th of August 2024. So it's essentially the promulgation of a timetable that meets the guillotine point that the government itself, through its own legislation, has imposed on this scheme. In this connection, sir, I should note that the Secretary of State for Business and Trade, Grant Shapps MP, stated in Parliament back on the 7th of December 2022, that's just under 5 months ago, on the announcement of the GLO scheme, that, quote, experts, and by that he meant lawyers and ADR specialists, should be on board by the early spring, at which point full claims can start to be submitted and assessed. I hope that compensation will start to flow before the summer and that most cases can be resolved before the end of 2023. So 3 things were suggested by the Secretary of State in terms of timing: claims being submitted and assessed in early spring, compensation flowing before the summer, and most cases resolved before the end of the year. That's a timetable to which the department and the Post Office ought reasonably to have been held, but it's seemingly slipped already. Claims cannot now be submitted and assessed in early spring, as that date has already passed. Payments will unlikely be made before the summer, And so you may consider that something new is required. We would suggest that you ought to be circumspect when considering the submission made by Mr. Jacobs to take on responsibility for setting the timetable yourself, given the role you perform, the statutory constraints upon it, and your terms of reference. But what you can do is ensure that those whose job this is do it properly. And you can set a timetable for a timetable. You can monitor compliance with it, and you can, if necessary, hold those responsible for delivering the timetable to account if they fail to comply with it. So that's all I say.
Thank you very much. Right, I think that brings to an end this compensation hearing. I will reflect upon the submissions that I've had in writing and orally, and deliver, I won't say a report or an update, I'll keep you all in suspense on that until you get it. But you will get something in writing as soon as I can muster it. Obviously, to an extent, my ability to produce something very quickly is hampered by the fact that we are starting to hear evidence again next week from, as many would think, very important witnesses. So you will have to bear with me to an extent, but you will have something sooner rather than later. Thank you all very much, and I'll see some of you on Tuesday morning.